And greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Please remind everybody to hit that like, share, and subscribe. There's a PayPal link down below for anybody that wants to share some love. And of course, the StreamYard link is there for anybody that wants to join the panel. We've got John and Russ with us again tonight. How you doing tonight, guys?
Guy from Iowa, how you doing?
I am well. I am well.
All right.
Doing well as well. Hope everybody else is in chat as well.
Good deal. Good deal. As you see the title, I had my meeting with the mayor, and I also went over and talked to the assistant district attorney today. So we're going to start with that before we get into the real party, which is we're talking about the real party and interest. So I've got some things pulled up on that to show how the if there's a real party and interest, then what are the other parties? So there's some kind of joinder. So we're going to go over those kind of things. In the meantime, I went down and had my little meeting with the mayor and just basically went over my companion's case about the credit collections and everything and let him know that I was going to start redressing things and that I expect to have cooperation at the local level. And he seemed completely well with that. He seemed to understand much of what I was talking about. I let him know that I know quite a bit about the trust and how I've spent my last 8 years and stuff, and the research that's brought me about, and how it's, I accept my own part in it, but it's time again that we're all adults. So when it comes to my specific cases, I expect cooperation and agreement at the local level simply to correct the records, because I'm not coming forth to make any accusations. I'm just pointing out material facts that show that there's something wrong, needs to be investigated, and it's just a matter of correcting them. I'm not out for any kind of retribution or anything. And so then when we got done with that meeting, and like I said, he understood that very well. I even talked a little bit about the bonds and how they work. And then I went over to the county attorney. Of course, again, upon his recommendation, and it goes right with Matthew 18, verse 15 through 20. If you guys would care to get into that and read that, that's basically how this system really works. And if you have aught with your brother, you go to him private first. That's why I wanted the private meeting with the mayor first. He's the executive at the local community. He is the head of the agency at that level. So then upon his recommendation, we go to the county attorney. If the county attorney doesn't listen, then we go to the state attorney general. And again, that's just the same process that it's talking about through the administrative process that we see in Matthew 18, verses 18 through 20. So that's where we're at. I did speak to the district attorney, like I said, though I wanted to talk to the DA. He wasn't in. But in the communication with the district attorney, I made some very poignant points about how the record is and what it shows. And he wanted to sit there, two things that kind of just, it tells you their mentality. And one of the things was when I mentioned that I'm giving him evidence of things in the record that show material alterations that could be conceived as criminal actions on the federal level, and that he was required to report things like that. I didn't want him to, well, no, we don't have anything to do with federal. Okay. So that's part of what we're going to talk about with the real party and interest. And that's one of the things I'm going to bring up at the next city council meeting this coming Monday, is the fact that even the municipal mayor under that charter has to be chartered under the Federal Register. On that Federal Register, that charter has to have a communication with the Federal Reserve in order to handle all those obligations and other securities of the United States. So they do have that agreement, and that is the congressional authority to lay and collect taxes, duties, imposts, and excises. So, and everything we do in this society that I've learned is based on that construct of the legal name using an address with the city, state, and zip.
How would they claim it's not federal when they're running off with the damn SS-16 that is the Federal Insurance Contribution Act? How does that even Iowa
Well,
wanted to.
well, that's what I'm saying. They have no way they can say they don't have anything to do with the federal, and that's where they actually get their delegation of powers. And that's a delegation of powers, not authority. Again, Congress shall lay and collect taxes, duties, imposts, and excises, and make rules for government, not the people. There aren't any rules for the people except common law. That's the access to equity. And that's what they're trying to deny. That's why they merged equity with common law so they could use contracts as a remedy and try to force you into contracts. Well, it's implied contracts from enumeration at birth. That's the creation of the financial institution of a legal name in their legal system. Just using it on an envelope through a postal service is showing that you're sending some kind of communication of an account. Whether it's a contract or a private letter, even a private letter is a private accounting of events and things that are going on. This is why it's so inherently imperative to understand the English language and how it works in the different jurisdictions. It morphs. So as soon as it enters into a jurisdiction outside of concise English, you are no longer under the true nature of its origination. It's now been morphed. That's the same thing that happens to the man that's been discharged of his mother's waters. And then they turn around and charge it as a legal man again without recognizing the spiritual credence, the living soul. Every breath is an act of life. And I get it from there, not somewhere over here collaterally along this plane. So
Keith, do you have any idea which one of these individuals actually holds that SS-16? Because I haven't quite figured that out. Somebody in the circuit has to hold it. But nobody wants to say, hey, I hold the hot potato. And I'm wondering if it is the district attorney and then the master commissioner / probate commissioner, depending in what area of the country you're in, acts as a liaison to the district attorney. Also with that Social Security number accounting. See what I'm saying?
Well, yeah, that's the county commissioner. See, you're going to have a board of
directors. That's the one for the master commissioner from the Social Security Administration that it holds all the accounting of the Social Security number in that county. That is the master commissioner, separate from the other commissioners.
Then wouldn't that be at your county Social Security office then?
Well, no, he's contracted through the state, through the Social Security Administration at the county level. But he's an independent contractor. So he's kind of the fat man behind the scenes at the Wizard of Oz, hiding right in the plain view, but out of view. Not even holding a they're third party contractors. And then he hires, in most cases you'll see, it will be the county attorney in the counties as the domestic relations commissioner, or the DRS, Domestic Relations Services, depending on where you're at. And they're using their state bar license under the state to go and collect these taxes or collect this child support and all of this stuff under Title IV.
There's no bar license.
Martin O'Malley is the Social Security Commissioner, and the Deputy Commissioner's space is vacant. Somebody could jump in there and do some educating. Chief of Staff. Senior advisor to the commissioner.
I looked at the one in Kenton County because obviously that's where I originated from, right? In that area. So when I looked up the master commissioner there in Kenton County, and there's one in every county for that Social Security Administration, and they're called the master commissioner. You can look it up. In Kentucky, it's in the revenue cabinet. But
Right there. Look,
revenue,
uh,
yeah.
Assistant Inspector General, Office of Audit, Michelle L. Anderson. I bet if you get a hold of her with the Freedom of Information Act to disclose who the public officer is in the public trust that is the taking care of these CC16s
SS.
or SS16s.
And you know what's crazy for elderly people and everything too? There's also an SSA 16 is for benefits.
I would put it out to all these guys. You know me. I like a fucking blanket job, musket fire. You know, shoot
Yeah,
everybody.
let me
Um,
tell you about this one in Kenton County real quick. So anyway, and I know that they're the ones that receive the federal funding, right? They get that FICA grant from the SS16, the election certificate of election coverage, the SS16. So they receive, the master commissioner is the receiver of those funds. He receives those funds, and he's the one that is accounting with the Social Security Administration, and he's not even a public official. He's a third-party contractor. But now check this out. When I look at him, he is the registered agent for Yogi Inc. You like Yogi Bear? And he's been in there since 2008, and that stems off to doctors, the Shriners, all kinds of stuff, folks. They're doing this right at our local levels, right under our faces.
yeah, and that's what that's what I talked about the mayor or talked with the mayor about today was those bonds and how they work. And I know that they hold a blanket bond for all the city employees and everything, and then of course the county has a blanket bond for all the county employees. And this is what I would go after if I had to do a forensic audit and set up a contract. In the meantime, I don't want a contract. I just want to correct the record. The
Correct.
correction of the record itself will revert anything that's owed back to me and my companion as it relates to the estate. That's all we want. We're not trying to make accusations and get recompense from anybody else or anything. That's according to him. That will weigh out according to him. You know. So in our efforts, again, we're not attacking the title or the office. We're attacking the record, and we are repenting because we're the ones that entered the data elements and didn't know what we were doing. In having said that, we have the right to correct that record, and if the people that are required to correct that record are refusing to do so and locking us up, that's the most egregious treason and seditious actions you can take. All it is information, and they're taking it out against the messenger as to the message. That proves we live in a demonic world. That proves that we're becoming Hitler's willing executioners. So let's get on to it. Real party of interest. As it relates to LII-WEX, dang it, it says here, a real party in interest is the person, which is a fiction, or the entity. So the person, as it relates to a predecessor, predicate, whatever, as it relates to reason and logic, person would be like the legal person, and the entity would be the entitlement, or the all caps. That's why all your corporations have all cap names on their documents. Who has the right to bring suit even though someone else would ultimately benefit from the suit if successful? For example, in relation to some group court, a Texas Court of Appeals case, a widow and child were the real parties in interest in a wrongful death action trying to collect damages because of defendant's alleged negligent killing of decedent husband father. That is, the widow and child have the right to sue the defendants, but the ultimate beneficiary is the decedent's estate, saying that you have to sue in the name of the decedent estate, the person. In the context of trusts, a trustee may file suit against a person who damaged a building owned by the trust. The real party in interest is the trustee. Notice we're talking trust terms here. So even in their court cases where they have a real party of interest, they're telling you the same thing I've been telling you. A contract is evidence of a trust, no matter how you look at it. Figure out what position you are in that trust, and it absolves your position in the contract if you do it correctly.
So
Even though
they can sue the record, Keith?
yes, we see it all the time. United States versus $18,427.76. They're suing the debt. The record is the debt. It is evidence of the debtor. Even though the trust beneficiaries ultimately benefit from the suit. So the estate is the name that you sue in, and then the beneficiaries benefit from that. Furthermore, many jurisdictions require that the suit be brought in the name of the real party in interest. For example, and this is why I tell you, the law is uniform throughout all jurisdictions, and there's equal protection of the laws among the states. So when I talk about Texas Rules of Civil Procedure that says that you cannot hire an attorney except through a board of directors, meaning that you have to be incorporated to such a point that you have a board of directors, comes to the incorporated status. You're not such status. You've not had that communication with Congress, and you've not had that communication with the Federal Reserve. For example, California Civil Procedure Code 367 states that every action must be prosecuted in the name of the real party in interest, except as otherwise provided by statute. So let me...
So they can't sue the real party in interest, Keith. That's
no,
what you're saying, right?
No, the real party in interest is the one that brings the claim as a plaintiff. A real party in interest being charged can bring another counterclaim as the real party in interest, rebutting and using Rule 12b 6, or actually I'd use all of them, 12b in whole, failure to bring a claim upon which relief can be granted. You're the fucking trustee. The state is bringing a claim as a trustee. Excuse me. You can't bring it in the name of the trustee. Oops.
Right. Social Security would have to be co-defendant, I think.
United States.
Yeah.
United States is the one that grants them their foreign trade zone to incorporate.
Well, see, that's what I see. What I think they're doing, they're transferring that right at the local level there, and they're converting the American people into residents of the state as United States citizens, and flipping the script, and everybody keeps going along with it and signing the transfer. Here you go. Here's the alteration. Take every damn thing I got. Keep me being a little bitch.
Yep. And greetings, Adam Lanza. How you doing tonight, brother?
Hey guys, good to be here. Thank you for having me, everybody.
Thanks for coming up. Appreciate all the support, guys. So let's
I wish
continue on.
More people would start joining, Keith.
Yep. I too. So we're done with that. Let's go on to the next one. The next one I got is from the Rules of Civil Procedure of Iowa, I believe. Let me see. Yes, Iowa Gov. Iowa Gov Docs. This is Iowa. It doesn't say it on here, but it's Chapter 1, Page 1. Very first thing is Rules of Civil Procedure. Federal Rules of Civil Procedure Rule 2 says there is one form of action, civil. There are no criminal actions. There are only remedies for criminal actions, but it still has to be done under an Article 3 court or criminal activity. They don't do that. They do it in the corporate courts, Article 1. So, Rule 1.201, real party and interest. Let's take a look. Notice that's the first thing they point out. Let's take a look at Rule 1.101 first, applicability. Statutes affected. The rules in this chapter shall govern the practice and procedure in all courts of the state, except where they expressly provide otherwise, or statutes not affected hereby provide different procedure in particular courts or cases, such as common law. Actions, joinder of actions and parties. Let me blow this up. Actions, joinder of actions and parties. Remember, you were talking about the Social Security at state level, right? As the co-defendant. In a sense, yeah, that's the origin of the statistical record is the Health and Human Services, actually.
Yes.
But the co-defendant or co-real interest in party is the United States because there's a joinder.
Which they're using the all caps in that and converting that Social Security number over to that firm.
Correct.
Through that AO 430 and doing the conversion right there, and then taking all of those and creating these Federal Reserve notes.
Yep.
It's the way I see it. I mean, through what I've been looking into pretty deep.
Well, yeah,
and I just happened to run over an email from a clerk of the courts there in Carrollton, and they were talking about the whole election where they moved the election facility, and said she was there at that time when they moved. It was CB, whatever it was, the Chicago Board of Salt and Exchange. So it made me look into who they were, and then I'm like, okay, well, why would they be? And it's the transfer of the securities. That's what they're transferring, and that's what those people are doing. I can pull that up and see it's CB, Chicago Board of shit, I forget.
Well, it's
hang on, let me get.
Basically, what we're trying to do is understand the concept of know thyself and how they're using these English words in their legalese to distort things to their benefit. So let's take a look at the next part. Real party and interest. Notice that's real party in interest, not on interest. Every action must be prosecuted in the name of the real party in interest. So again, we have it under Iowa Civil Rules of Procedure, just like we saw it in the federal thing here, real party in interest. It said, according to California Civil Procedures, every action must be prosecuted in the name of the real party in interest, except as otherwise provided by statute. Saying the same thing here. Every action must be prosecuted in the name of the real party in interest. But an executor, administrator, that's why I talked to the mayor, he's the one executing this stuff, is evidence of a trust. You're the executive. I'm the benefactor. He knows that now. I gave him lawful notice. I performed the first duty in law is legal notice. I recognize the trust. I'm the benefactor. You're the executive. Administrator, conservator, guardian, trustee of an express trust. Or a party with whom or in whose name a contract is made for another's benefit. Or a party specially authorized by statute may sue in that person's own name without joining the party for whose benefit the action is prosecuted. This is what they're doing in the court. You're the benefitter, or the one that's supposed to benefit, and they're not giving you the joinder.
Yep, that's called failure to join an indispensable party. I think that's what it's called.
Correct. And that indispensable party is the benefactor who gives to the beneficiary who is supposed to be able to enjoy the beneficial use of the benefit. No action shall be dismissed on the ground that it is not prosecuted in the name of the real party in interest until a reasonable time has been allowed after objection for ratification of commencement of the action by or joinder or substitution of last name, firm name, substitution of the real party in interest, and such ratification, joinder, or substitution shall have the same effect as if the action had been commenced in the name of the real party in interest. So as a defendant, they substitute because that would create a joinder of the real party in person, or real party in interest of the person. Same thing with the address. It's another expression of a trust, and they taught you how to express a trust, but not which one.
That title, Keith, was CBOE, and it's Chicago Board of Options Exchange.
California Board of Options Exchange.
Chicago Board.
Chicago
Options
Board
Exchange.
of Options Exchange.
Yeah, they exchange commodities and raw materials. Derivatives refer to a type of financial contract who is dependent on an underlying asset.
Yeah, and that's a derivative of the Chicago stockyards from when the cattle drives used to go north and south from Texas and stuff, all the way up to Chicago to the stockyards there. And I believe it now has a modern connection with NASDAQ.
Right, and that Master Commissioner is Master Commissioner's Finance and Administration Cabinet. Finance, it's Kentucky.gov. FinanceKentucky.gov.
Right, and I think it acts like a centralized point of transfer of what they call state blue sky securities. If you look under your state, you're going to find
Yes.
blue sky securities laws for your state. Those are the same thing as the federal securities laws, and that's what they're doing is they're using conversions and then running them through the state securities as if though they're issued by the state, when in fact they're private issues. They were issued by us. We just didn't know what we were issuing. Now that we understand that, we can go back and rescind those signatures and have those records corrected. Again, not causing any unjust dues upon anybody else, but certainly making all parties whole. So the next one is Rule 1.202, public bond. When a bond or other instrument, what kind of instrument? Government instrument, financial instrument, contractual instrument, school instrument, medical instrument? What are we talking about? So there's ambiguity there, but it relates to the predecessor. This is the predicate to a public bond, which is a monetary instrument, a financial instrument issued by the government. So it would be an obligation or other securities of the United States given to the state, county, school, or other municipal corporation. And that obligation or other security as an issue could be a private issue. And that's, I think, the main thing that we're losing here is that we're actually making private issues. We're not public officers. We're not public agents. Though the presumption is there, and that's the way the record flows. So our ability is merely just to correct the record. We make ourselves whole in this by doing it righteously and justly. Just the record. I'm not here to make any accusations to any officer or person. It is intended for the security of the public generally, all for your safety, folks, or of particular individuals, internationally protected persons, and their American interests. Action may be brought thereon in the name of any person intended to be thus secured. So when they bring the name of the defendant in the entitled name, the all upper caps name, that's the United States entitlement. Okay? The legal name is the upper and lowercase first and last name. And that's been secured. It's recognized as a security, and it must be secured under an entitlement, and that means it must be in all caps. It means it has to have a presumed incorporated status of being organized under the laws of the United States. That was the intent of the enumeration at birth and the conference of a nationality of a United States citizen known as a United States business, is so that you could incorporate it in an agreement with the United States as a co-creditor under full faith and credit.
So it's unorganized at birth, Keith, and they attach the 9-digit number, then it's suddenly organized.
Correct. Presumed to be operating in a capacity availed to it. And it's never been availed because nobody's ever taught this. So when it comes to that incorporation, let me drop down. Let's go to the next page first. But before we do that, I'm going to pop up here. Looks like we lost our brother here. I have corporations and business associations selected statutes, rules, and forms. Now, it seems like it's just a book, Charles R. O'Kelly Jr., Robert B. Thompson. But it actually talks about Revised Model Business Corporations Act. It is a federal government act. And it says here under Article 2.03, for official comment, conclusiveness of Secretary of State's action on question of individual liability for corporate actions. Remember, we were talking yesterday, it's about the actions perceived to be similar to performing the same functions as that of an office. That's all it takes is your actions. If your actions are similar to a corporate action, that's what it's going to be presumed at. Under Section 2.03b, the filing of the articles of incorporation as evidenced by return of the stamped copy of the articles with the fee receipt is conclusive proof that all conditions precedent to incorporation have been met, except in proceedings brought by the state. Now, when the credit collectors come after me for a debt, an obligation or other security of the United States, and they think they have to prove their incorporation, they fail to understand 22 CFR 93.1 and 93.2. Under notice of filing of suit, you have to notice somebody else of filing a suit of like kind. They too must be incorporated into such a capacity that they too can hire an attorney to make a representation of the corporate estate in those courts. Article 1, courts. Thus, the filing of articles of incorporation is conclusive as to the existence of limited liability for persons who enter into transactions on behalf of the corporation. That's what we've been doing. We've been entering into transactions on behalf of the corporation. If articles of incorporation have not been filed, Section 2.04 generally imposes personal liability on all persons who prematurely act as or on behalf of a corporation, knowing that the articles have not been filed. See, we've been acting on behalf of a corporation, but we didn't know that there were no articles of incorporation filed, nor did we know that we were actually acting on behalf of a corporation. Section 2.04 may protect some of these persons to a limited extent. However, see the official comment to that section. All persons purporting to act as or on behalf of a corporation, knowing there was no incorporation under this act, are jointly and severally liable for all liabilities created while so acting. That's to say that if the person purporting to act as or on behalf of a corporation did not know there was no incorporation under this act, are jointly and severally liable for all liabilities, are not liable. They are not liable at all, severally or jointly, because there was no joinder.
That's why we have the UCC, Keith, for limited function responsible parties.
Is that in the UCC? I've not come across that.
No, that's just John Harnick's summation of why we have the one reason why we have the UCC for the agents that are limited function responsible parties. If there's no disclosure, Keith, they can't expect us to be fully culpable here for what they're doing. If we don't know, then we don't know. That's why we have 3-402.
Yep.
A lot of people in our movement,
absolutely.
right? They thought it was 1-308. So you're just a representative.
Yeah. And you were authorized to do so. Under that authorization, you have a knowing and unknowing, and that's where the liability lies. So, let's get back to it here.
You know,
Rule
it's
7.
another thing real quick. You know, I know you were talking about the way the prescriptions and everything are done and everything. And I took my mother not long ago to pick up her prescriptions, and where she actually has to sign for certain prescriptions, it plainly says right there, authorized representative.
Yep.
I mean, it's not hidden in the line. I mean, it plainly says right there where she signs, authorized representative.
Well, yeah, and look on the top corner of that document, and you'll see in yellow highlight with red or black ink, it will have the first 4 letters of her last name. That's the firm name. So she is representing a firm. What kind of a firm? An investment firm.
Yep.
That's why it's entered into the court registry investment system. They're using it as an investment, therefore it's considered an investment firm. What is an investment? Remember that? Under the NASDAQ securities, or under the NASDAQ definitions, we saw security and investment. Investment is the creation of money. They're creating money in those courts. That's what they're doing. That's what an investment does.
That's what's got me thinking, because the court is a circuit, so you have the master commissioner, which is not even a public official, but is the one that does the accounting for the Social Security Administration of the Social Security number, and the clerk hanging out with the CBOE. Are they doing all of this on the paperwork, and then they're doing the exchange through the CBOE guy?
I have no idea. Everything's electronic. I bet they don't even have any idea.
Well, that's what I'm kind of getting at here. I mean, these guys are probably being played right at the level, and they think they're so smart and they're doing
Absolutely.
the right thing and everything, and they're being played like a fiddle.
Absolutely. That's why I say the left hand doesn't know what the right hand's doing, and it's also indicative that these people are indoctrinated just as much as I was. You know, so.
Right. I wish that people would come together out here and more people would start to pick up on some of the stuff. Because, like it's like I said the other night, Keith. I think at some point, once we get back and we figured out what they done, we had to start somewhere to take back some kind of reason and logic to all of this stuff.
Yep.
And it would
Now,
be nice if people felt that they had a support system, though, is what I'm getting at in the grand scheme of things.
well, and this is your support system. It's unlearning everything you've learned. I don't care who taught you. You can't trust them. Do not believe your neighbor. Do not believe me. Do
Absolutely.
not believe the government. For crying out loud, do not believe your mother, even if she homeschooled you. Go beyond. Get objective viewpoints from everybody else and see if what you learned is a greater truth or a subjective truth to something else. So under Rule 17, remember the language we just went over under real party and interest in those codes and stuff. Rule 17, plaintiff and defendant capacity. Public officers. That's to say that public officers have the capacity of being a plaintiff or defendant. This is a resident, federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board. Okay? Real party and interest. A. Designation in general. An action must be prosecuted in the name of the real party in interest. Here we go. There's 3 times: California, Iowa, and this, as well as the definition of real party in interest here. So, the following may sue in their own names without joining the person for whose benefit the action is brought. And here we see that list again: an executor, administrator, guardian, bailee, a trustee of an express trust, a party for whom or in whose name a contract has been made for another's benefit. Now we see the federal term. It says a contract has been made for another's benefit. So we see in this language that is both a contract and trust, because it says contract in it, and it says for another's benefit, proving the intent of the action. First is a trust. NG, a party authorized by statute. Action in the name of the United States for another's use or benefit. When a federal statute so provides, an action for another's use or benefit must be brought in the name of the United States. Is that an end of story, guys?
Well, it certainly is for me.
22 CFR 93.1. Diplomatic notice. They have to be filed through diplomatic channels. In other words, the state has to communicate with the United States to let them know they're filing a suit in the interest of the United States.
Yep, they got to tell the State Department every time they drag your ass into court.
And they fail to do so by filing it in the interest of what? The state. Claiming the
Void
state.
already.
Claiming the state is the real party in interest. No. See, the real party in interest, if the state does something fucked up, is the United States. Again, I am not posing that you go to any of these state courts. As people, our venue is common law through the federal court, Supreme Court, as a matter of equity to put them in line. They're the ones that are contracting, and they're doing so in the name of a non-party or a party that doesn't have the full interest. Yeah, they may have some interest, but they're not the real party in interest. They're a fiction. Look at that name. Look at the thing running across the top. It's all uppercase. in and for the Blackhawk County, or Iowa District Courts in and for Blackhawk County. Well, that's the Iowa District Courts is a corporate entity, right? And they're putting for me a contractual document that they want me to sign in contract capacity. Yet when I try to put Benefactor down there, oh no, you can't do that. And fuck, I can't. The trust is already expressed. Are you not the public servant of the public trust? Meaning you're the trustee, not me. So that leaves me, since you got your grant from the federal government of that public trust. They're the grantee, you're the trustee, and whom the fuck am I then? I'm your motherfucking benefactor.
Right, Keith, if we're not the agent, the vendor, or the shareholder of the plaintiff, then who are they? They can't sue you.
Exactly. So let's go to the next one. Let's first go down here let's look at joinder. It says joinder of real party in interest. The court may not dismiss an action for failure to prosecute in the name of the real party in interest until after an objection, a reasonable time has been allowed for the real party in interest to ratify, join, or be substituted in the action. So, what I have is material fact evidence that there has already been false joinder, unknown conditions that are now known after discovery. And first duty of law is to give legal notice. And now I'm giving them notice. And the only notice I have to give them is that I notice the expression of the public trust. I am the real party in interest, and I was granted a nationality of United States citizen, an internationally protected person, and that is being used against me, and therefore I have real party of interest in the United States, but they can't act on their own, so I have to grant them that interest under 50 U.S.C. 4305B2, full acquittance and discharge for the United States, in the interest of the United States, for the account of the United States, and for the person making the same, so that no person shall be held liable in any court. It's a dismissal of the liabilities so that there can be acquittance and discharge.
Okay, so they need our permission to move forward.
Correct. We're the ones being violated, not the state. The state's the one doing the violating. They're not going to go forth. So we really got to think about this stuff. And again, I urge you, get back to concise English. Understand how this stuff works, and it will correlate, as I'm showing you here. Real party in interest that we read both in the LII-WEX definition and the Iowa statutes correlate to public defendant capacity as a public officer. And now, under Rule 18, joinder of claims, a party asserting a claim, counterclaim, cross-claim, or third-party claim may join as independent or alternative claims as many claims as it has against an opposing party. All 94 of them.
Starting to see why everybody's in your business now.
Joinder of contingent claims. A party may join two claims, even though one of them is contingent on the disposition of the other, but the court may grant relief only in accordance with the party's relative substantive rights. This is why we talk about our relative substantive rights, because we are not the person. We are what's known as the relator, relative to it, because it is the next of kin, or we are the next of kin in that kind of a relationship, that it cannot exist without me. Period. In particular, a plaintiff may state a claim for money and a claim to set aside a conveyance that is fraudulent as to that plaintiff, without first obtaining a judgment for the money. All 94 of them. Set aside a conveyance that is fraudulent as to the plaintiff. The plaintiff in all 94 of those cases, claiming to be the real party in interest and using my name through the court registry investment system and converting it and the social security number and converting it, shows that an unlawful conversion was made. I don't care by who. Nobody can make the claim of real party in interest because I never authorized it knowingly.
Right. We're just like an emergency contact person, Keith,
Correct.
for
Data
court
elements.
dates.
Data elements.
So how are they getting authority to move forward then? If we never approved of it. It's amazing.
Absolutely. That's why I say this is plain writing, folks. I hope you guys are competent enough. I think you are. Most of you, for the most part, are competent enough to understand this just like I do. And it's reiterated it time and again here tonight. All of this is the same language. And it's just telling us the same thing over and over again. So let's look at Rule 19. Rule 19 talks about required joinder of parties. Persons required to be joined if feasible. Required party, a person who is subject to service of process. Who's subject to service of process, folks?
Agencies that they that created.
Come on. You know me. I like my homemade stamps. The postman.
What?
United States Postal Service is the registered service agent, correct?
Oh shit! Yeah.
Yep. So why are we in these administrative courts? If a person who is subject to service of process, that says a person who is, not is to be subject, but is subject. It's a now time. Who is subject to service of process, folks? One last time.
Post office. Damn it. Or service.
Yep.
So we're not even supposed to open the mail then, Keith.
Nope.
That's me. Ah, okay. Got it.
So making that connection there with the mayor and the whole local government and the municipality through the SS16 and the master commissioner being the liaison to the circuit and the executive judge, for there to be a transfer of property, there has to be a stamp.
Collateral tax stamp. Collateral transfer tax stamp is what it's called. Tax Stamp Act. Read it.
So that's what they're doing at the CBOE, whatever with that process right there is.
And Tribe, you're ahead of me. I appreciate it. Wish you'd come up on panel sometime, though, dude.
Absolutely.
So we're going to take a look at the next rule. Rule 19. We really it's kind of entailed there, but we really don't need to go beyond service of process. Who is subject, not a volunteer on the private side. We're talking about public obligations and securities. A person who is subject to service of process. Okay. Rule 301, presumptions in civil cases generally. In a civil case, unless a federal statute or these rules provide otherwise, the party against whom a presumption is directed has the burden of producing evidence to rebut the presumption. But this rule does not shift the burden of persuasion, which remains on the party who had it originally. What's the best defense? And I'm going to say in my opinion, but I'm hoping you guys will see it as well.
What popped out at me there was the persuasion, because they will try to persuade you in every way possible to get you to break.
Absolutely, and the presumption is the debt belongs to you. But
Yeah.
we beat the presumption with 18 U.S.C. 8, obligation or other security of the United States.
And
The
they
term
need to get you to admit to that and consent to that.
right. The term obligation or other security of the United States includes all bonds. See, they have to have an import-export bond in order to be granted that trade zone. So they already have a bond with the Customs Service for import and export of merchandise, entry and admission of merchandise, and importers, exporters. Certificates of indebtedness, national bank currency, Federal Reserve notes, Federal Reserve Bank notes, coupons, United States notes, Treasury notes, gold certificates, silver certificates, fractional notes, certificates of deposit. Those are the ones that I'm talking about with that birth certificate. You deposit it, it's a certificate of deposit, special deposit, where once it's deposited, it's the unpaid balance of money or its equivalent, wherein that financial institution is required to extend the credits if they haven't already done so. Checks or drafts for money drawn by or upon authorized officers of the United States.
That representative.
This is my favorite part because after United States, you see that nice little simple comma, space. Stamps and other representatives of value, comma. That's all lowercase. That's plain writing. I don't know how you escape that. Stamps and other representatives of value. What is your value? What is your value system as you sit here and try to collect a debt against me? And then you're going to sit there and try to use the Postal Service against me. Well, they're the ones that put out the weights and scales, and it's the Swiss Confederacy that has the Swiss franc that the Universal Postal Union goes by. But of course, we're still not talking about the inherent value of Jeremiah 51:31, post to post. Excuse me. One post shall run to meet another, messenger to messenger, shewing unto the king of Babylon that the city is fallen at the other end. There's a greater truth. I'm not putting up with your bullshit fiction anymore. I am real.
It's that whole post to post, and if you look, when I was looking into that whole circuit, and that's how that's set up, county to county, post to post, all bam, 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 bam.
Exclusive use. Exclusive fair use. 17 U.S.C. 107. As you see scrolling across the bottom of the screen, we'll read that real quick. Let me get to my banners. It says, fair use, all clips are used for fair use commentary, criticism, and educational purposes. See, again, I'm not using them against them. I'm using them to reconcile a record through a full acquittal and discharge by giving a directive to investigate the record for its errors that I know are there, here, and here, and we just need to fix them. Nobody's going to be held liable. Fair use. Everybody's going to learn. And it may be critical, and you may not like what I have to say, but understand, I used to be the bitch-ass slave too.
So that's why court summons always go on the back porch. They try to get
Right.
you to open it.
Right. And under the next banner, I've got several of these. Fair use under 17 U.S.C. 107 for non-monetized commentary and discussion for satire, comedy, drama, or even newsworthy entertainment only. Let's see. We've got this one here that says, got my email and everything there in my site.
What's sharing screen?
It's scrolling at the bottom, brother.
Oh,
I'm changing the banner.
Oh,
So you can see I've got several of these, and it says after my Wyrd Wyzard at wordwisewarrior.art, my email. Feel free to use it. It's in the details of all these videos. Fair use commentary, 17 U.S.C. 107. Limitations on exclusive rights. Fair use free education review only. So they can't assert exclusive rights except under commercial transactions. So if I'm not using it for commerce, then they can't say that. It's important to understand English and learn how these laws are written so you can use them against them, because that's what they might think, is that if I use statutes, codes, rules, and regulations, that it would be accepting a benefit. No. I'm using it to correct the record, and everybody's going to benefit. Because if I use it only to correct the record instead of attacking your title or your office, you might end up in prison. I don't want that. You use the verbiage. Use just the verbiage. I believe I'm under exclusive fair use, exclusive rights limitations according to the law. Now it would behoove them to find the statute that says that, because I already know. I don't have to use the statute. I use the verbiage. See, I don't go down to these people and write all this stuff in these private letters. I use the verbiage, and it would behoove them to educate themselves and find it. I did. Now, if they don't believe that, and they say that they're just doing their job and that they can't accept that, now I have a reason, because I gave them, first duty of law is legal notice. I gave them legal notice that what they were doing is violating my rights by saying I couldn't use this content. Nobody has a content claim against it that they can use against somebody that's not monetizing it. It's for educational purposes only. And again, that's my whole premise in coming forth with this community. I'm not out here trying to accuse anybody and get them thrown into prison. That was my concept when I first, 8 years ago, started doing this research and got hooked up in sentenced to 60 days in jail and stuff. I wanted to come sue them. I'm understanding I don't have that capacity. Again, to file a suit in those courts, you have to have a board of directors. So you can't use the Article 1 courts. You have to stay out of those. You have to learn how to draw the republic back and come back with the third or Article 3 courts. People of your peers, people that are willing to travel around without the necessary identifications that say you're a United States citizen or a resident.
Yep. So we'll stay out of what is it, Article 1 legislative tribunals, right, Keith?
Yep. I would be putting 40 stat 41 Q section 7E and 48 stat 112 on all my documents from now on. That's in reference to the public monies and how we have no access to pay in our real coin. And so we're using fiat currency under the Bank Emergency Act. And that's public House Joint Resolution 192 and Public Law 7310. So anyway, as we move forth, this is the kind of information I'll be presenting to the City Council and letting them know that there are certain things that you have to be culpable for, and that is a knowing. And if you're trying to profess that you're trustees in this trust and don't know how a trust operates, and that when in fact one of the benefactors comes forth to you from the community and gives you facts that are pertinent to the trust, and you deny him, and that denies him the benefit, you are in malfeasance of trust. And when a public servant like the district attorney's assistant comes at me, let me see here. Under 18 U.S. Code 1001, 18 U.S. Code 4, my apologies. Let me pull it up on screen for everybody. Because when a public servant comes to me and tells me that they have no duty in law to be a mandatory reporter of felonies and crimes and stuff being committed against the very people that they're supposed to be protecting, I'm going to shove it right down his throat. So let's take a look at 18 U.S.C. 4, misprision of felony. Whoever, having knowledge of the actual commission of a felony cognizable by the court of the United States, conceals and does not, as soon as possible, make known to some judge or other person in civil or military authority under the United States, shall be fined under this title or imprisoned not more than 3 years or both. Already, just by denying it, you're taking upon a 3-year sentence. To alter it, after I've given you notice not to alter it because I've discovered the alteration, that would be 20 years. Because now you're forcing me to do shit. That's forced labor. And that's abuse or threatened abuse of the law or legal system, civil, administrative, or otherwise, for a purpose which was not intended. And again, these are Article 1 courts. They're intended for corporate activities, not my private affairs. Stay the fuck out of my business. So with that, we come to the conclusion of tonight's stream.
Some of these judges, though, I remember that last time I went in front of that one up there in Pennsylvania. And, that's when they the time they cattle herded me in the court up there after, I'd done the notice of special appearance objecting to any personal jurisdiction. And then after that, I just basically said to hell with them. And they came back to me again, and then she had them cattle herd me in there. And I brought up about that notice and everything, and she said, well, I have jurisdiction. And I says, no, how would you possibly have jurisdiction? And she said, well, because I was voted in. I said, and I looked at her. And I said, because you're voted in, that gives you jurisdiction over the living man and woman. Yes. Well, you're out of your mind. I mean, what state of mind is that lady in? What state of mind is these people in, folks?
Well, that's what I'm saying. These people take upon the emoluments because of a contract and don't understand that contract has to be constructed under a trust, and therefore they're taking upon a trust position. And they think that, well, their trust position in that is the job, and their benefit is the payment. So they must be the beneficiary.
Right.
Sick.
It is. It really is sick. I went and revisited all the body cam footage of those 3 officers. And it was funny because when the one went up to the window there and they said that I had 3 warrants or whatnot, she wrote down, she did before anything, she wrote down on a piece of paper, grabbed a pen and piece of paper and wrote it down where the camera wouldn't see anything, what it was that he was there for and what I was there for. And they wouldn't even show it. It's insane. These folks, they know what they're doing. I'm at the point now that certain ones of them, it's absolutely, how could you not know? Just like that woman sit there and tell me that just because she was voted in, that gave her jurisdiction over the living man and woman. That woman is in a spell of illness, son, and is insane.
Yeah. They think the office is where they get their authority. They don't have authority. They have a service responsibility. They're confused for sure. In the meantime, before we leave out tonight, I want to let everybody know this coming Monday is another city council meeting, so I'll be going to that, and I'll be doing a live stream from my phone on El Perro. I did do a live stream yesterday or the day before, a test on it, asking for help on figuring out how to get my subscription opened up on my phone, because it's only allowing me to do the regular StreamYard stuff. It doesn't allow me to do my backgrounds or anything like that, even though I've got a subscription on my laptop and I need to get it to sync up with my phone or something. So if anybody knows how to do that, please let me know.
Can you run StreamYards off on your YouTube Live on a mobile?
Yeah, well, on my laptop I can. I stream it to 3 channels.
Yeah, that's your laptop, but I'm not sure you can broadcast from your phone like that.
Well, that's what I'm wondering. It says if I paid a subscription on a device to be able to cast from that device, and I have it on one but not another, and they're going to tell me I need to no, there's a synchronization of data elements that should work the same. That's the only thing I'm wondering. So anyway, so when it comes to the attorney, we're going to set up an appointment. We're going to call down tomorrow and set up an appointment with the DA, the actual district attorney. And the idiot today wanted to know if I had power of attorney documents to even discuss it with him. So we're going to bypass that. We do have them. She's got her will. She's got her powers of attorney and everything. She's got her trust expressed. But we're just going to have her come down and we'll deal with it in person. And he can look her in the face as he tries to victimize or take advantage of her. I'm not going to be nice. That's my companion. I'm her ultimate protector. And you're not going to sit there across some table and placate some idiocy to me. For damn sure. Anything else, guys?
No, I'm good. I'll go out the same way I always do, encouraging people to be the change you wish to see. Big things are coming, I think. I'm kind of excited. I kind of been laying low lately, and curing my own mind, and I think big things are coming. Much love, everybody. John, good to see you. Keith, always a pleasure, brother. Many blessings.
Yeah.
Absolute.
Yeah.
Appreciate your support, brother. How about you, John?
Well, thanks for the headache, but I enjoyed it.
Well, hopefully the more we learn about this stuff, and like I hope I showed you tonight, the correlation of real party in interest, plaintiff, defendant, and public officer, resident, United States, it all ties together. It's all corporate, and there's a preconceived and presumed limited liability simply because you act like it. So again, actions speak louder than words. If you don't know the words, then people are going to learn by your actions. So why don't you? So think about that, folks. And you know me, I love you, but I don't give a rat's ass whether you love me back. And that's to say, if I don't care if you hate me, I don't care if you don't respect me. And that's on you. So may God bless you and have a good night. Bye now.